everyone. I'm so excited to be here today to speak to you about the legal side of growing and scaling and perhaps even someday selling your bookkeeping business. So I'm going to jump right in because we have a lot to get through today and I want to make the most of our time. So my name is Paige Hulse. I'm an attorney based out of Tulsa, Oklahoma. I have been an entrepreneur and small business owner since 2017 when I left my former firm to start my law firm, Paige Hulse Law, and soon thereafter my second business, the Creative Law Shop. So I'll mention both of those a little bit more later on, but I just wanted to say very truthfully, especially because you provide professional services, I provide professional services for our clients. I do not at all underestimate or I do not take for granted the role that you play in your clients' businesses. Oftentimes, when things go south and unfortunately an attorney is called in retroactively to help with the lawsuit is what I'm dancing around here. I know that the work that you provide can be the make it or break it factor in terms of some of the lawsuits that I deal with. So I am honored and very excited to speak to you all today about some tips that maybe could apply to your own business to help make your own business legally sound in the same way that you help your clients. Okay, before we get started, I'm going to have to be really boring and read you my disclaimer just so that I can stay legal myself. And so the law requires that I tell you that while I'm an attorney, I'm not your attorney unless and until we sign a client agreement. Everything I'm going to be talking about today is for general educational purposes only. If you have any follow-up questions about anything that I'm speaking about today, please, you're welcome to book an inquiry call with me, or please reach out to an attorney in your jurisdiction to help you further clarify those questions. Okay, so just really briefly, what we're going to be talking about today, we're going to be hitting on three different topics ish. Here I am already sounding like a lawyer. We're going to be hitting on like three, but more like six topics. We're going to talk about briefly intellectual property as it pertains to copyrights. We're going to be getting into more detail when it comes to intellectual property as it pertains to trademarking. This is going to be critical for every single one of you listening to this video. And then third, we're going to be looking ahead, which is just a catch-all for those other topics that you've probably heard on other seminars or you've heard at other workshops, etc., that are extremely important. But I want to start with the former because I don't hear them spoken about as frequently in circles such as this. And this is information that is critical to you. So with that, we will go ahead and dive in. Okay, oops, I'm so sorry. There we go. Okay, so first and foremost, at my law firm, Paige Hulse Law, I practice primarily, I would say 90% of my time is spent on intellectual property matters. So this is what I'm spending all day, every day doing. So briefly, as an overview, intellectual property pertains to copyrights, trademarks, patents. We are not going to be talking about patents today. Those protect inventions. And unfortunately, none of us have invented the art of bookkeeping, so we can't claim any rights to that. Trademarks, as you can see here, protection of brand identifiers, so name, logo, slogan. We're going to get into that in quite a bit of detail, but I'm actually going to start with copyrights. We're going to go through this relatively quickly because this is the one area that could pertain to most of you, most likely, but maybe I can't guarantee will pertain to everybody. So I want to just make sure that I raise the awareness of copywriting for you in case you aren't sure which category you fall into. This is the protection of original works of authorship, such as books, photos, online courses, etc. So we're going to start with copyright law. Okay, so as you can see here under the 1976 Act, and as I mentioned already, copyrights are the form of intellectual property that cover a tangible work of art is the easiest way to define it. So again, when we're thinking about copywriting as it pertains to bookkeeping specifically, the client files that you create for your clients, for example, or the spreadsheets that you create for your clients, those arguably could fall under the realm of copywriting, but as a strategic business owner, that's not the angle I'm coming at this from. What I am wanting to impart to you today is if there is any other element of your business aside from the pure just bookkeeping business or the bookkeeping work that you're doing with your clients, you need to be well aware of copyright law. What I'm getting at here is if you have something like an online course or an educational component or a website or any sort of lead generator, email opt-in, anything like that, this is where copyright law comes into play. So just to clarify that quickly. One thing to note as well is that we're not going to talk about common law copyright law today, just simply for the sake of time. However, when you actually create that work of authorship, you automatically do have rights under U.S. laws that protect the copyright rights that you have. One thing I want to note really quickly here is I should have started with this, and my apologies for not. I'm licensed in the United States. Everything I'm talking about pertains to U.S. law. However, I can tell you definitively that quite a few international or non-U.S. companies, actually, the laws follow U.S. laws, or they mimic or mirror U.S. laws very closely. So this may not be exactly, the statutes may not exactly apply to you, but they're going to be pretty on par. So again, the basic concept of copyright law is originality, not whether or not the work is novel. So we're not talking about inventions here. We're talking about what you created, what you need to protect. Oops. Okay, there we go. So when we're looking at what constitutes copyright infringement, in order to prove that somebody has actually copied you, and this again really comes into play primarily with any sort of online business owner, whether we know it or not, we are creating common law works of authorship, common law copyright materials. However, in order to prove that somebody, and let me back up for a moment here. We all know as online business owners that it's very easy to put something out into the world through our marketing, through, again, lead generators, if there's an educational component to our business, etc. Very easy for someone to learn from it and then replicate it. That gray area and that line of what is inspiration and what is infringement, obviously very much a gray area, and that's where copyright law comes into play. So in order to prove infringement, if somebody is actually copying or is actually ripping off your work, you have to establish actual ownership of the copyright. So what I'm getting at here is, as recently, this was 2019, the United States Supreme Court ruled that you must register your copyright before you can actually sue somebody for infringing upon your copyright. What this means, guys, is that if you have not registered your copyright and you see somebody replicating your work or, again, ripping you off, you can send them a cease and desist letter, and it could go pretty far. It could turn into a negotiation, and more than 80% of cases do end in settlement before trial. But in order to actually be able to act upon that cease and desist letter, you have to have a registered copyright. You can't just rely on common law copyright rules or common law copyright laws. If the person that you're sending a cease and desist letter to knows that, if they're savvy to that, they're going to get that letter and they're going to laugh at you. I'm being a bit dramatic there, but you see where I'm going with this. I don't let, just for what it's worth, I won't write a cease and desist letter for my clients unless and until we can prove that unless and until I know that we have that next step in place where we can take action on what we're threatening to take action on. Otherwise, they're just hollow words. So this is why it's important at the outset to determine or to decide whether or not you want to register your copyright rights. Again, when we're looking at what falls under copyright law, or copyright protection, I should say, and what to register. The term works of authorship is that's vague. That's hard to define, and that can cover a myriad of um, things that we're creating. So what I typically tell people, and you'll see this and it should be, by the way, at the bottom of your own website. But what I tell people is something like your website. So you need to have that copyright notice at the bottom of the website, because that is equivalent to you sticking a flag in the sand and putting the world on notice that you are claiming ownership to your own common law copyright rights to that website. If somebody actually ripped off your website, you would not be able to sue them for that, because I do not recommend to my own clients that they copyright their websites. Briefly hitting on this because it's a common question that arises. The reason why I do not recommend that my clients register the copyright for their websites is because every time you make any alteration to this fixed work of authorship, again, going back to the actual legal definition, fixed work of authorship, you have to re-register, or you have to register a new application. So that means anytime that you upload a new blog post, or you change out a photo, or you update the copy on the website, you would have to go register the copyright again. I'm a business owner. I'm a lawyer and a business owner. From a legal perspective, sure, we want to have copyright ownership to everything that we can. As a business owner, and putting my business hat on for a second, that's not practical, nor would I say prudent to file those copyright rights for your website over and over and over again. Okay, another common question that comes up is fair use. So this comes up when, or it usually comes up in inquiry calls when my clients are trying to determine, when they're in the process of creating something and they're trying to determine how much of something else they can use. So somebody else's copyrighted work, which I know that's a very vague way of explaining it. But for example, if we're looking at, if you're putting together a course and you're collecting a lot of different information or photographs or whatever that may be that you're including in the course, you're going to have to look at fair use laws, and you're going to have to see if what you are using that you did not actually create falls within this 4-factor test, which I will not read out to you. I'll let you read that, but it can be very, very nuanced. Okay, I know we are moving through copyrights quickly. That is because I really want to hit on trademark law. While copywriting, again, may not completely pertain to everybody listening to this or watching this video, I can almost guarantee you, and I say almost because I'm a lawyer and we don't make promises, I can almost guarantee you that trademarking applies to every single one of you. And that is because trademarking covers, it's the part of intellectual property that covers any word, phrase, symbol, design, or combination thereof of your brand. So in other words, this is what protects your brand identifiers. Where this comes into play most frequently with business owners is first business name, and then logo, and then slogan. Sometimes logo and slogan in terms of priority get switched, but I'll come back to that. So the trademark is very simply the legacy of your brand. And that's not something I don't say that just to sound cliche. That is because your trademark, going back to this briefly, your trademark, this is your business reputation. We all started our businesses most likely not necessarily purely because we love marketing. We love having to reinvent ourselves all the time. I mean, I'm a serial entrepreneur. Of course, there's a side to that. That's not what I'm talking about. When I build something, I want to build it strong. I want to build it sound, and I want that reputation to last. And I sure as heck don't want to have to go back through the business and change my business name and reinvent myself and try to get my audience back on board with figuring out who the heck I am if all of a sudden I have a new name, new reputation, etc. What I'm getting at here is until you trademark your business name, you do not own the name. The asterisk that I would add to this note is if you, like myself with my law firm, if you operate your business under your surname, so under your last name, trademark law does not apply to surnames in the United States. And I'm not licensed again out of the US, but I can tell you that that is true international or in non-US countries as well. So for example, my law firm, Paige Hulse Law, I don't have that name trademarked because it falls under that caveat in or that exception in under US law regarding surnames. I will say I say all this, I have trademarked successfully the business name of a business that has been around. They've been around in their community for about 60 to 70 years. And so that business, as that business owner is passing on the business to his children and grandchildren, he wanted that name to endure. That name had taken on a separate and new meaning, disassociated with him as an individual. I won't get into that too much more right now. You can email me for follow-up questions there. But what I'm getting at is if you have a business that operates under your name, then you don't need to worry so much about the fear of losing your business name. Nobody can take your last name away from you. Again, using myself as an example though, if you have a business that is something other than your surname, such as my second business, the Creative Law Shop, you need to trademark that because whoever, and I'm kind of jumping ahead here, but whoever trademarks first owns it. I'll get into that. So a trademark works in two important ways. It distinguishes your products or services from others that could be similar. And again, it helps protect your brand and guard against frauds or copycats or people trying to not necessarily impersonate you, but people who are maybe looking a little too closely at your business. This is why in order to build a business strategically and a business that will grow, a business that is legally sound, every business owner needs to know the basics about trademark law before they even name their business. Now, if you're watching this, you probably already have a named business. This all still applies to you. So while I want in writing, I want it to say before you begin operating your business, I know that most of you most likely already have a business in operation. This still applies to you. I just want to be clear that if you're going to start a new business or a new startup, or if you're like me and start one up every couple of years, keep this in mind moving forward. You need to run a legal due diligence search. I say it here in bold on purpose. This needs to be the number one takeaway that you take from this video. I don't care how long you have run your business or operated your business under its current business name. You still need to run a legal due diligence search. And I'm going to just skip through this because obviously this is redundant, but this is also how important this is intentional redundancy. That's how important it is. The reason being is if your brand were to raise what's called a likelihood of confusion with another brand, you could very easily wind up in legal hot water. So in the US, and again, in most jurisdictions, this likelihood of confusion does not necessarily mean that something has to be the exact same or a name has to be the exact same as another registered name or as another business name. In order to raise likelihood of confusion, it can be as loose. This is a very, very loose term. It can be something that's just phonetically similar or even just visually similar. There's a lot more to add to this, and I'll come back to this in a second. So the reason why I say if you fail to run a legal due diligence search, and by that I mean have an attorney. This is not a Google search. This is not seeing if domains are available. This is an attorney running a knockout search. If you fail to do this before investing and building up your reputation, you could be forced to start all over again. If you're like me and you're watching this video and you're thinking to yourself, well, I've been running my business for 5, 6, 7, 10 years. Um, I I know that I have rights to the name. You're not wrong. You're not wrong. We'll get to it a little bit. You have what are called common law trademark rights, but those are not going to be easy to enforce if they're even enforceable. And again, I'm skipping ahead, so I'll come back to this in a minute, but I just want to flag that if you're listening to this and you're thinking, if you're thinking to yourself, this doesn't apply to me, it actually does. So why a lawyer? You need to have a lawyer run a due diligence search. Is because, and again, I know that I'm talking right. This slide is talking about choosing a business name wisely. You might already have your business name, but the reason why you need to have a lawyer run a due diligence search is because for example, when I run a due diligence search for my clients, I actually hire out a whole search team. They comb through not just the United States Patent and Trademark Office, they also comb through every single reference on a common law basis, internationally, things used colloquially, just in common day vernacular. My best example is I've had somebody, I trademarked a magazine, and the due diligence search brought up a reference to the magazine name from a newspaper article in 1972. So that's a very extreme example. However, that's just an example of how diligent these searches are. And again, I want to be very clear that I'm distinguishing this from your typical just Google search. The other reason is because when it comes to likelihood of confusion in the United States, we're talking about visual similarities, we're talking about phonetic similarities, but we're also talking about classes. So we're talking about the actual goods or services that your business is producing to the client or customer. So what I'm getting to with that is that can be a good trademark attorney is going to be very strategic about how we define the goods and services that the business actually operates under. For example, I will always, every trademark application I file, I will always create the widest net of protection possible by adding just as many subclasses as humanly possible to the application, so that if somebody does come along and they are kind of flirting with that line of likelihood of confusion, we can build even wider walls, as I say, around the client's business. So I'm going to briefly hit on what you can't trademark: generic or descriptive terms. So if you, an example with this would be like, if you wanted to create a course that was called like bookkeeper education, you wouldn't be able to trademark that. That is descriptive of what it actually does. So that's something to keep in mind also as you're thinking about naming your business. Okay, this is what I mentioned earlier that I started to talk about, and I knew that I wanted to come back to. Yes, when you start using a trademark, so a name, a logo, or a slogan, generally speaking, this can also cover colors and sound and smells, but those are very rare. Common law rights aren't going to carry that far. So a trademark exists with respect to commercial activity. In order to have an enforceable trademark, it has to be used in commerce. So an example of this is I have a client who has an educational component to her business, and she deals with more infringement than most business owners. I think maybe the most infringement that I've ever seen from any business owner. And so she wanted to go through her course and start trademarking elements of the course that were kind of catchphrases or things that she caught herself saying all the time. I had to break the news to her that we could not do that because she was not selling the course and using those terms in connection with commercial activity. So when we're talking about commercial activity, I'm not going to sit on this for too long because it can get in the weeds really quickly. But when it comes to commercial activity, this is going to pertain to what the brand identifier, so the name, logo, or slogan that you are using to sell any services or products to your clients or customers. So when we're talking about common law trademark rights, you can't enforce common law trademark rights unless you satisfy a few requirements first, one of them being geographical area, or again, similar goods or services. Goods and services, that's we all know what that means. That's if something's similar, if a lawyer can make an argument that something's similar, then great. Geographical area is something that our legal system is trying to catch up with, because in the age of online marketing, what constitutes a geographical area. In the past, in the past, and I'm not going to talk about the case law of common law trademark rights throughout the United States history, but in the past that could be, state to state. Now it's very, very broad. And the other thing to add here, and I don't want to spend too much time on this, but the other thing to add here is that the party also has to show prior use. So you have to show that you have been using this name much longer than the person that you are trying to take action against. And I will tell you also that in order to take action to enforce common law trademark rights, we're talking about a usually very protracted court case, so a very expensive endeavor. It's going to take a while. It's going to be in federal court. It's going to be really expensive. So the reason why I'm mentioning this right now, in terms of just challenging a trademark, if somebody with a business name that is similar to your own has registered their trademark, actually not in the process of it, but has actually registered their trademark, your only option is to try to pursue common law trademark rights. Again, we're easily talking about at least a $50,000, bottom line, or baseline, at least a $50,000 lawsuit. More commonly, we're talking at least a $100,000 lawsuit, just in order to keep using your business name, or to get out from, or as the defendant, to get out from under a lawsuit if they have sued you or sent you a cease and desist letter saying that you have to change your name. Even if you've been using your name longer, even if you've been around for years and years and years and they're brand new, but they trademarked it, as a defendant, you are still going to have to try to weave something out of this argument and spend a lot of money on attorney's fees in federal court to do so. I can tell you that that is not something that you want to do. So the takeaway from this is, when it comes to trademarking, this is something that you need to first assess what you have, what assets within the business can be trademarked, and then when you need to trademark them. Time is key. When it comes to federal, or when it comes to registering your trademark, it's essentially, I think I might say this in one of the later slides, but it is essentially a race to the courthouse. So whomever files first gets heard first. And I will come back and talk about this a bit more. So again, until you register your trademark federally, you don't own it. I don't care how long you've been in business, you don't own it. Once you have a federal registration, then you have the ability to overcome any claim by later users of good faith. This ties back into our common law trademark rights conversation. And I know I'm kind of flirting with getting in the weeds and also completely avoiding talking about it in too much detail. But what you need to know about this is that in order to win a common law trademark dispute, the element of faith, of good faith or bad faith, comes into play. When you have a federal registration, that negate, and that's a very vague term. That's where the attorney's fees start to get really expensive, because we can draw that argument out for quite some time. Once you have the federal registration, you don't have to worry about that anymore, because the government is saying that the federal government is saying that you own that name. And again, when I say name, I'm also talking about logo and slogan. So What a federal registration allows you to do is, instead of going through that long, protracted court case that I've been talking about, a federal registration allows you to essentially file one document in court and enjoin or legally stop somebody from infringing upon your trademark. That is at least a $50,000 difference in cost. This, if I were to file, when I file that document for somebody in court, it's, it's only a few hours of fees worth. The cheapest case I've ever had in federal court was $50,000, and it was about 10 months long. And that was a short one. That was very, very short. Okay, I digress. Let's get back to this. When we're talking about federal registration, this also provides you as a trademark owner with statutory rights such as incontestability. So what this is saying is that once you've registered the trademark, then anybody that wants to challenge your rights to the name, they're going to have the burden of proof. They're going to have the big fight. They're going to have the money fight. Literally, they're going to have to pony up all those attorney's fees, and that's going to be very, 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 very hard for them to do, as I've already, I think, explained ad nauseum at this point. The other element that I would throw in here as well, just thinking as a lawyer when I'm looking at issues like this, is that if somebody has not trademarked their name, if my client has trademarked their name and somebody is sending it, and this has happened before, somebody sent them a cease and desist letter saying, I've been using that name for 20 years. You don't have rights to it, blah, 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 blah. My client freaked out at first when she got that letter, because of course nobody wants to get no one wants a cease and desist letter. But what I immediately told her is, if they want to actually fight this fight, again, they're probably looking at 6 figures of attorney's fees. B, if they're looking at 6 figures of attorney's fees, that raises the question of why they didn't take those simple and relatively very cheap step of trademarking ahead of time. So it's an easy way for myself as a lawyer. I can immediately call a bluff when looking at those types of cases. You don't want to be the person that somebody's calling a bluff on. That is not professional. That's not what we're here to do. Okay, we've talked about attorney's fees enough. I'm gonna bounce on through here. So one of the most common questions I get is, when do we need to trademark? We've already shown why we need to trademark. We've shown what it covers. When do you need to do so? You can see, I'm not going to read this off. You can see here, but you guys, really what I want to get at here is, the minute that you have a name, logo, or slogan that would hamstring your business to have to revise, and by revise, I mean would hamstring your business if you had to recreate your reputation and reinvent yourself, that's when you need to trademark. I will tell you that trademark fees, of course, just when we're looking at the process in general, because we're business owners, and this is where, again, I can talk about all of this from the legal perspective, obviously putting my lawyer hat on, but putting my own business owner hat on for a moment. Obviously costs come into play, and just we have to look at this from the 10,000 foot perspective. We can't just be reactive and be looking 90 days ahead. So when looking at this from the 10,000 foot perspective, the process is going to range between $3,000 and $5,000 probably by the end of the day, just to shoot you straight. That's going to vary depending on where you're located. Although I will say any attorney in the United States can file within the United States. So if you live somewhere like New York, where attorney's fees are astronomically high, you can find somebody out of state that might not be so high. The other thing to look at too, and this is updated at literally as recently as this morning. The process is now, in this post-COVID world, the USPTO was slowed down significantly, and applications are taking 12 to 18 months to process. So this is not something where you wake up one day, you decide to trademark, you file the application, and then you get the application. it is a year-long, at least a year-long fight. And this is where you want to use an attorney that is well-versed in trademark law. When we're looking at the question of when, the other question, and again, especially when I'm talking to a group like this, you're professionals. You didn't just wake up one day and randomly decide to start a bookkeeping business. You are professionals and you provide professional services for your clients. And so with that, you probably know that if you don't have a trademark for your brand already, it's something that you need to look at doing. So then again, when we're looking at the question of when, you can see here on our second note here, produce a specimen. That's just a weird way that the government, that's the weird term that the government uses it for exhibit. So proof that you are using that name in connection to commerce. So in other words, and I'll skip ahead here and I am going to hit on this briefly. So you need to file when you are using the name in commerce. However, if you, like myself, I just started my 4th startup about a year ago. I filed my trademarks under what's called a 1B application a year before anybody knew the business existed. So a year before I could prove use in commerce, before I could prove I had any clients or customers, I filed an application under what's called a 1B application. The reason why so briefly, there are 2 types of applications in the United States, 1A and 1B. 1A pertains to any marks that are being used in commerce right now. So for example, if I had not filed the trademark for the Creative Law Shop yet, that business is up and running and selling, and it's been around for a little while and it's been doing that for a little while, I would file what's called a 1A in use application. For the startup that I wanted to keep a secret for a little while, I filed a 1B application, meaning I intend to use it. I have a bona fide intent to use the name in commerce within a certain amount of time. So very simple at the end of the day. The pros and cons of why you would choose one or the other. As you can see here, you can read through this here. But what I really want to get at, guys, is that the reason why it's prudent to file a 1B application if you don't actually have everything that the attorney needs to prepare the application yet is it gives you a head start on this process that is long and arduous. It used to, pre-COVID, the process would take about 6 to 9 months. Again, now post-COVID, it takes 12 to 18 months. So when you file a 1B application, you get started in that process. I'm not going to go through every step of the process because I could keep you here for hours. And as interesting as I'm trying to make this content, I assume that you don't want to listen to the law for hours. So when we're talking about the trademarking process, your attorney is going to work hopefully very hard and very quickly to get that application filed ASAP. And then it's going to be this right now about 8-month period, 8 to 12 month period on, or 8 to 12 month period of waiting before the application gets assigned to an examining attorney. So where the 1B application comes into play is that you get started in that queue. You get started in that 8 to 12 month waiting period. And then later on, the attorney comes in and amends the application to be a 1A application. And that amendment only requires that we screenshot your website and show that we're using the name in commerce now. So as you can see here, it's just an additional filing fee per class. It's a no-brainer. And take it for what it's worth. But as a trademark attorney and as also a serial entrepreneur, I proceed with 1B trademarks, and it's not a question in my mind, and this is why. In the United States, and I think this is true in non-US countries as well, but again, I won't conclusively say so, but in the United States, trademarking it could be considered what's called a race to the courthouse. So whoever files first gets heard first. So the quick antidote I want to share here as an example is I had a client a couple years ago who launched a rebrand of her business. She got excited. We had gone through the due diligence search already. We had We had cleared the new name she wanted to operate under. She got very excited about relaunching. And so she actually relaunched her new brand within like a week or two before she had told me she was going to. She forgot to tell me that she had done so. She called me sobbing about an hour and a half after she relaunched her new website because she had gotten a cease and desist letter. Before I even opened the letter, I looked up the person who had sent the letter and saw in the USPTO system that they had not registered their trademark. So I immediately filed my client's trademark application, and then I responded to the letter. The next morning, the company that sent the cease and desist letter filed their own application. Because our application was lodged in the system just a mere 12, maybe 18 hours before the other companies, ours was heard first, and we just won that trademark battle. So you can't just sit around and wait. I'm going to very briefly hit on this question, but for the sake of time, I'm not going to very long. This is a question I get all the time, and without getting in the weeds too much, I can tell you that you should not trademark. You should not trademark your business name and logo together. I won't do it for people. You can see the pros here. The cons are, if you do this, if you trademark your name and your logo together, you must actually use them together at all times to maintain your legal protection under federal law. That's why I won't do it for people. And that's just my own integrity choice within my own business, but I just want to impart that on you. When you're looking at your business and looking at what you should trademark in order of priority, and again, looking at it as a business owner, I always recommend to my clients that they start with their business name, because that's going to be the hardest to reinvent. That's going to be I don't need to explain that anymore. It's harder to reinvent your business name. Your logo or your slogan might not be quite as hard to reinvent. It depends business to business. I have 4 businesses I've trademarked aside from my law firm. I've trademarked the elements of all of them. But when looking at which one I start with, it's always the business name. And then it depends on, with my 2 of my other startups, it depended on the nature of the business itself. So for one of them, I filed the logo before I filed the slogan. The other one was vice versa. And that was because for my other startup, I thought of the business because of the genesis of the business came from coming up with the slogan and then seeing all those puzzle pieces fit together. So anyways, that's just something that's something I talk through in depth when on calls with clients. Okay, we're not, and again, more considerations as to why you don't want to file together, but for the sake of time, I'm going to skip on through here. Very quickly, I get asked this every single day. No matter what you take away from this video, if you decide that you don't want to ever trademark, that's fine. You can still use the TM symbol after your business name, logo, or slogan, but you cannot use the registration symbol unless and until you have the registration. So using the TM symbol is equivalent to how we discussed earlier, using the copyright symbol in the footer of the website. You don't actually have the registered rights to it, but you're putting your flag in the sand and saying, world, I am putting you on notice that I claim ownership of my common law trademark rights here. So the other thing too that I want to note about this is that in the United States, it's kind of funny. It's the TM symbol can be used both for common law trademark rights, and it can be used for registered trademark rights. So it works in both scenarios. So I always tell people, no matter what you choose to do, go ahead and start putting that TM symbol, A, because it's smart. B, if you decide to trademark later on, it takes a while to find all of the different references of your business throughout your website and all the content you put out, etc. If you miss a spot here or there, you've already covered yourself by putting the TM symbol. So anyways, I jumped ahead there. I apologize. Okay, so that wraps up the intellectual property part of this conversation. If you have follow-up questions, because I whipped through a lot of content in a very short amount of time. If you have follow-up questions about anything that I just discussed, you can find me at paigehulse.com. You'll see a link to my website at the end, but that is my law firm is an intellectual property law firm. So you can find articles on everything I talked about as well. However, because you're probably not here just to talk about intellectual property, and because we are here to talk about building legally sound businesses, I want to make sure that we're hitting on some other elements that come into play, excuse me, frequently with my own bookkeeping clients that I work with. I know this is a weird one to start with, but let's just get it out of the way. You need to have an estate plan. As I say here, I don't care how old you are, you need to have an estate plan. This is something that no one I feel like nobody in the entrepreneurial or online business space talks about. But you can start. I had my estate plan drafted when I was 26 years old. There were extenuating circumstances I'm obviously not going to get into, but you can have your estate plan drafted, and then your assets and your family is covered in the case of the unknown or unforeseeable. And then you can go back through and just amend it every 10 years or so if you want to, if you need to. So you need to add to it's a fallacy, it is false, and it's a lie if somebody says that it's too soon for you to have an estate plan. I don't think I can be any more blunt. You need to go meet with an estate planning attorney. This is something that falls within state regulations, obviously country regulations as well. So this is where you need to meet with an attorney in your state. And as business owners and as bookkeepers, I'm going to just go ahead and assume, and we're going to talk about it a little bit. I'm going to assume that you have an entity for your business. Make sure that your estate planning attorney is aware of that, and make sure that they assign the entity into the estate plan. Okay. Hiring considerations. Again, I drafted this up after, literally after getting off a call with one of my clients who's a bookkeeper. Given the nature of your job, you understand designations between contractors and employees more than the average entrepreneur. So I'm not going to sit here and explain the difference between a contractor and an employee. If you have questions about it, I have free resources on all of that at the link I'll share at the end. However, one thing I do want to note, given, again, the nature of your business, is obviously you need to have a contract specifying the designation of their employment status, whether that's a contractor or an employee. I can tell you from experience that a judge will hold you to a higher standard in court if you are in court having to figure this out. Because given the nature of the work that you do, there's an imputed knowledge in terms of the judge is going to know that you should have known better. That's what it comes down to at the end of the day. So anyway, I digress. What I want to mention specifically as it pertains to bookkeeping businesses is make sure that you include a confidentiality provision within your employment agreements as well as your client agreements. But within your employment agreements, I also would require that the people that work with you or for you sign an NDA. This might be that might be overly conservative advice, but I'm fine with that. That is, my job is to protect my clients, and so I'm going to do so conservatively when need be. And you're looking at the back end of, obviously, the back end of people's businesses, and you're looking at a lot of you're looking at, I don't need to explain to you, obviously, that when it comes to bookkeeping, people get funny about money. So having an NDA, having anyone that works for you sign an NDA is not just going to be a level of protection, although it is going to be a critical level of protection, but it's also going to be, in my opinion, a hallmark of your professionalism as well. Okay, so contractual considerations. I didn't want to spend much of today talking about contracts. Because you can go read, I have articles, I have every single article on contracts, years of being a contract litigator, on my shop website, which I'll give you the link to here in a second, that describe pretty much everything that I would be sharing with you right now. But, and the other reason too is I know that a lot of times in these types of conversations, the conversation revolves around contracts. And why I wanted to spend a lot of the time speaking about intellectual property is intellectual property requires more foresight, requires more forethought. It is something that's not discussed as frequently. It's the valuable information that you sign up for an event like this to hear about. Contracts are obviously critically important. And if you don't have a contract for your client already, or for your clients already, then that's a separate conversation. You need to get a contract immediately. And I'll show you where you can get one here in a second. But I know that contracts come up in conversation more frequently, so I wanted to kind of shake it up a little bit. With that being said, obviously with any business, but with my bookkeeping clients in particular, there are some patterns that arise in terms of the contractual considerations that come up, the disputes that arise. If I were to boil them down to two different types of disputes, that would be, as I say here, how clear are you on the scope of the project? The second be, well, let me stick on that for a second. When I say the scope of the project, I mean, how clear are you in terms of telling the client exactly what you're going to be providing to them so that they don't feel like they're caught off guard or surprised or, et cetera, later on down the road, which could lead obviously to a dispute. So an example of this that actually I'll use myself as an example, this might make me look like a fool, but that's okay. When I started my business and hired my first bookkeeper, I did not know that there was a difference between the regular, like monthly, bookkeeping services that I was providing and reconciliation services within QuickBooks. And so when she charged me for something that she had to reconcile, that whatever, I won't get into that too much. It caught me off guard, and I didn't like feeling caught off guard. Obviously, I'd read the contract. Obviously, I wrote the contract. But it was something I wish that she had flagged for me, just so I didn't have that awkward feeling of like, it just felt weird. You don't want your clients to feel like that. So make sure that you are really clear on the scope of the project. I didn't add it into the slide, but I also want to say, make sure that you're very clear as well regarding termination provisions within the contract. Make sure that your contract specifies the right for you to terminate the client relationship if need be. And not just that, but how it happens and when it happens. So how you could fire a client if you have to, or vice versa. I would recommend that be specified, that it needs to be in written. The notice needs to be in written form. And I would also specify that it is when it becomes effective. So is it due upon receipt, or is it effective upon receipt, or is it effective 30 days after, etc. That's something, and I can speak from my own from some of my own business experiences. I had with it I'm not going to get into details, but recently I had something come up where somebody I worked with, I had written in a clause that it was only one sentence long. It wasn't a clause, but I just said termination was effective upon receipt, upon the receiving party receiving notice, written notice. So when I emailed her, it was effective. And that ended up saving tens of thousands of dollars. She thought that she was going to have she thought that the notice would go into effect 30 days later, and that ended up being something that saved the business. So don't overlook their contracts. One word can make all the difference. Okay, moving on to our second point here. What are the rules regarding a failure to provide you with information? So I call this a pause clause within a lot of my client conversations, just because have you given yourself the right to pause the services if they if the client doesn't provide you what they need, or if they just ghost you for a few months. And then, of course, all the follow-up questions that come there, such as what constitutes a pause, what happens, are fees suspended, do you still charge monthly, all of those questions that follow afterwards. I added this in here because A, I know it happens a lot. B, I would argue that it actually happens within your industry more than the average industry, just because, again, people are funny about money. And sometimes they don't want to, like, I always put off sending my bank statements, which isn't good, but it's not something I enjoy doing. So anyways, it's important to make sure that your contract specifies what happens in the event of a pause. I spent too long talking already, so I can't get into this too much, but if you have not heard of what's called piercing the corporate veil, I want you to go to the shop, either of my websites, and you can just search it in the blog post. But when we're talking about business legality, and we're talking about the importance of LLCs and business structures, formations, etc., I litigate this frequently on both sides of the case in terms of trying to pierce the corporate veil or defending against piercing the corporate veil. What that means is when I'm suing somebody trying to pierce the corporate veil, I am trying to prove that they don't have an LLC. And so I can, therefore, on behalf of my client, try to access more of their assets, right? So when it comes to piercing the corporate veil cases, one of the primary factors of piercing the corporate veil is commingling of funds. The reason why I wanted to mention this here is because the work that, I'm not being trite when I say that the work you do is important. The work that you do has literally beat me in court before, and it's also been the wind beneath my wings in court before, in terms of proving that a client either has however I want the argument to play out. In terms of proving if a client has commingled their funds or not. So make sure that you are, I was intentionally vague with this last sentence here, but make sure that you're maintaining and preserving all of your client files as long as the law requires. And that can be like, I know I can't speak on behalf of your governing body or your licensing body, but that might be 3 years, it might be 5 years, etc. Hold on to those files. Make sure you do so as long as you're supposed to. Okay, the last quick note that I want to end on is disclaimers. Make sure that you are using proper disclaimers. And again, I'm intentionally vague here, but make sure that you're using proper disclaimers everywhere that you're dispensing information. So just like I started this video, make sure if you're speaking, make sure on your websites, put it in your footer so that it's accessible from any point in the website. Make sure that you include the disclaimer that, again, your licensing body, if there is one, requires, but if there's not a licensing body that you're acting under, make sure that you have a disclaimer that states that basically any information that somebody takes from whatever it is, that your presentation, your website, etc., that it's for educational purposes. You're not giving financial advice. I intentionally, because I'm not allowed to, I intentionally didn't write the provision in there, but it needs to just make sure that you stated, just like, again, like I did, that it's not financial advice. Okay, that summarizes a very fast rundown of some very important aspects of business law and just growing and scaling a legally sound business. I've mentioned both a few times now, but I have the two businesses. I have the Creative Law Shop. This is where I have every contract I've written. I've redacted the names, and this including my own bookkeeping contract. Redacted the names and uploaded them into the shop as templates. You get portals. So anytime, I'm in court all the time defending contracts. So anytime I decide to change something or add something, like if the judge recommends that we should have had a certain line in the contract, you get the updated version. So you can go to shopcreativelaw.com, and I will tell you at the time of this video comes out, we're going to have a big Black Friday sale. So keep an eye out on the website. Any follow-ups that you have regarding trademarking or intellectual property, you can go to paigehulse.com. This is my home website. This is where all of my intellectual property and just entrepreneurial information can be found. So Again, thank you guys so much for listening to me today and for being here. I truly hope that this has been helpful. And I hope that this is going to be a very valuable asset as you grow and scale your own legally sound business. So.